Welcome back to Court TV Live. I'm Michael Ayala. It is day 2 of the Uvalde school massacre trial going on in Corpus Christi, Texas. And there's already concern that it could end in a mistrial. Former Uvalde School District Police Officer Adrian Gonzales faces charges of child endangerment and abandonment in connection to the deadly school shooting back in 2022. Now, yesterday, the defense objected to some testimony from a teacher. Her name was Stephanie Hale. You see her there. She has to not have her face shown. And she described what the shooter was wearing and his proximity to the defendant. Well, they say that's new information and could be a Brady violation, could be exculpatory information. Well, right now the parties are discussing that issue. They are outside the presence of the jury here, so let's go in for those arguments.
It'll be sealed. Ballot, but you asked that it be sealed after you.
Yeah, it'll be sealed.
Thank you.
And you had your notes, Ms. Mitchell?
The record reflects that I'm tendering to the court my notes, all of my notes. Tendering to the court my notes on witness Aaron Robin and Maria Chavez, who are also teachers that would be located on the south end of the building.
Okay, these also were tendered to me in camera, so they'll be sealed as well after I review them.
I just wanted to also clarify for the record, Your Honor. So yesterday when I testified, after I testified, I, off the record, told opposing counsel, and I want to put this on the record, that I had not reviewed Stephanie Hale's interview with the Rangers at the time that she appeared for trial preparation. I went back to my notes. We interviewed her on December the 10th. At that time, I had not reviewed her testimony to the Rangers. It wasn't until the week of Christmas, I think all around December 26th, is when I started pulling the witness interviews with the Rangers that I reviewed her actual testimony to the Rangers. So the position that I should have had an epiphany on December the 10th when we interviewed her in anticipation of trial is misplaced, and I just wanted to make sure that that was on the record to clarify.
Yes, Your Honor, and our position on that would have been the epiphany should have occurred on the 26th when she reviewed it.
Okay, well, I'm going to review these documents that have been tendered to me in camera, but I will obviously at this point take any motions or arguments as far as remedies or proceedings in this matter. So, defense?
Yes, Your Honor. So, as the court will see from what's been tendered as far as our defensive strategy, this situation did have a significant effect on the strategy from voir dire all the way through, and through future witnesses, should they be called. We're in a position where we know under the law that we have to ask the court for a mistrial to preserve the record. However, if the court was not inclined to grant a mistrial, we do have other remedies we'd like to discuss.
Well, let me just say this. Under Heath, the greatly awaited case from the Court of Criminal Appeals about the court's discretion and power to basically, if there is a Brady violation or a Morton violation, to have the ability to exclude that testimony. And they clarified that the prosecutors, it does not have to be an intentional act. And I'll say for the record that I find, based upon what we heard yesterday, that this was not an intentional act. At best, it was a negligent act, or at worst. So I do have the remedies under Heath available, but, if you're making your motion for mistrial, I will tell you I don't believe what I've heard so far without reading although I have summarized what you gave me, and I kind of already had an idea of what it was. So I guess my question is, since we talked about yesterday, the three things that were complained about was the puffing, her seeing the dirt being puffed up. Number two, identifying or saying that she saw the individual for the first time, and the location. All right, my question is on the location issue that she testified to yesterday, and frankly, I think that was kind of a very quick testimony. I'm not sure that it resonated with the jury, but my question is there going to be other witnesses that put that individual in the same location that are going to be called later by the state?
Your Honor, I would say the most probably compelling testimony are the casings in the case that would either corroborate or override what she said. I believe the location that she placed, she's from probably in the neighborhood of 100 yards away, looking toward the south end of the building, and she puts, I believe she marked, in a general area south of the building. The casings are going to be closer toward the west side of the building. That is, they're going to be further west by as much as 10 yards. I haven't figured the exact date. So a witness from 100 yards away placing a witness within a 10-yard distance, that would be the distinction. The other potential witness, Melanie Flores, Melanie Flores testified that, would testify that the gunman, as she saw the children go into the south door, she saw the gunman at the south and west corner of the building, which I believe her testimony will put it halfway between where the casings were and where this witness says it was.
Okay. Well, I did a little research last evening, and again, I don't want to. I've reviewed your in-camera explanation of how this affects your defense strategy, and I had already kind of gleaned what it was. So I can tell you, I'm going to deny the motion for mistrial. You have made it, and you've preserved your record. Again,
Yes, Your Honor. In addition, can I just, so I can make sure it's clear, because we all know how the courts start interpreting it later. We will go with whatever remedy the court decides that we can decide it. However, we do not believe that it's a sufficient remedy, and mistrial would be the appropriate.
Yeah, again, I'm going to deny the motion for mistrial over your objection, obviously. And I'm going to find under Heath, although it's not a prerequisite, that it was not intentional by the district attorney's office. It was negligent, and I don't believe what was testified to in front of the jury resonated enough to significantly affect your trial strategy. But what I am going to do under Heath is I'm going to exclude her testimony.
We have just before you do that, really, I just want to know we have a response to if you would consider that. So.
We would also have a response to that, and just so we can explain it.
All right, so as you heard there, the really important parts, the defense, the judge, is going to deny the defense's motion for a mistrial. He said that, in fact, he didn't find that prosecutors intentionally kept this information from the defense. It was basically negligent, and that it wasn't enough to undermine the defense's case. So we're going to hear more of that. Right now, we'll take a break. We'll have much, much more from that courtroom when we come back. You don't want to miss it. Keep it here on Court TV, your front row seat to justice.
School shooting that broke hearts around the country and broke trust with law enforcement.
Now, the officer sworn to protect those students faces a jury.
The Uvalde school massacre trial. Live coverage today on Court TV.
Tonight on Closing Arguments, new developments in the murders of Rob and Michelle Reiner. We'll show you everything you may have missed as we preview what is next.
Closing Arguments with Vinny Politan. Tonight at 8, 7 Central, only on Court TV.
I've reviewed your in-camera explanation of how this affects your defense strategy, and I had already kind of gleaned what it was. So I can tell you, I'm going to deny the motion for mistrial. You have made it, and you've preserved your record. Again,
Yes, Your Honor. In addition, can I just, so I can put.
All right, folks, we are in Corpus Christi, Texas today for day 2 of the Uvalde school massacre trial of former police officer Adrian Gonzales. Prosecutors say Gonzales arrived at Robb Elementary School before the gunman entered the school, killing 19 students and 2 teachers, but he didn't do enough to stop the shooter. Now, moments ago, outside the jury's presence, the judge denied the defense's request for a mistrial due to potentially new information in a teacher's testimony yesterday. yesterday, but he says he will exclude her testimony. I want to bring back in my guest, still with us, Marie Pereira, as well as Jamie White joining us from Michigan. Jamie, I'll start with you. I want to get your reaction to what the judge ruled and what he said.
Yeah, I mean, you know, we talked about this in the previous segment. The judge has broad discretion here, and from his point of view, a mistrial would have been an overreach. I do find it interesting his ruling, though, in the sense that Michael, you know, he talked a great deal about this being an accident by the prosecutor, and that's just not required as a matter of law, either Texas law or pursuant to Brady. So, you know, I expect this to be appealed if he's convicted, and the argument will be that he put too much emphasis on the fact that this was negligence and not intentional.
It was interesting, though, Marie, because what he talked about was this other ruling by the appeals court suggesting that, I think you called it Heath, there was a case, Heath, that said if it wasn't intentional, then he has more discretion. And he said, well, he didn't find it was intentional based on testimony by prosecutors, felt it was negligent. So I'd love to get your response.
I didn't think that the judge was going to rule for a mistrial because it wasn't, in my opinion, enough. It wasn't intentional, it wasn't egregious, and it didn't completely obliterate any type of neutrality in terms of the ears of the jurors, right? I think the remedy is to, like he said, just keep that testimony out and keep it moving, because it wasn't irreparable. The testimony didn't make the case just horrible for the defense. And I think there will be an appeal, like Jamie says, and he did say, your objection is preserved, the record is preserved, you can, you know, fight it at the next level, but for now, it's not egregious enough and irreparable enough for me to shut it down, and I'm not doing that, and he didn't.
Yeah, fair enough. And Jamie, I think part of the strategy by the defense in making this objection, number one, you have to preserve the right to appeal, but also with the press conference outside, it all plays into this idea that this is an unfair prosecution, right? They believe that their defendant is being targeted unfairly by prosecutors, that he should not be in this particular position. And this sort of gave fuel to that fire. And that's why they made such a big deal of it, I think, not only in court, but also outside on the courthouse steps.
Yeah, I certainly agree with you. You know, again, there is this undercurrent that this man is being prosecuted based on the extreme attention internationally that this case garnered, and for clearly behavior that, at least from a layman's point of view, was inconsistent with what you'd expect of a police officer. So anything they can do to bring attention to the fact that things are being done, you know, maybe suggesting they were done intentionally or negligently, is going to help that premise. But, you know, we also talked about how seeing the future is impossible in these cases, and now with the testimony excluded, they can't go in and make an argument that, yeah, some people thought they saw it here, some people thought they saw it there, and create this ambiance of, yeah, it happened, yes, he was in this area, but we don't really know what he saw because other people don't know what they saw. So interesting turn of events. I agree with Marie, not surprised. I think the judge exercised discretion he was authorized to do.
Yeah, no doubt. But Jamie raises a good point, Marie, in that excluding the testimony, I think, ends up in part hurting the defense, because as you heard, there's going to be a couple of other witnesses going to testify they saw him in different places. And again, he talked about the shell casings being perhaps dispositive of where he was, and folks seeing him 10 feet away. Someone saw him from 100 yards away, saw him in this particular place. All of that could have ended up being helpful for the defense. But now this particular testimony is going to be excluded.
It's excluded in the world of judge paper. But do you really think the jurors are going to unhear it? I think he should, and he did do his job on cross-examination, and let the jurors, the trier of fact, decide her account, how accurate was it, right? Because when she first gave her account, she didn't say, I saw a tall monster with black hair. And all of a sudden, on the stand, she said it. So it just goes to her credibility as a witness. And each witness, you could take what they said, all of it to be true, or none of it to be true, or even a little bit, right? So let the jurors do their job. And he did a good job on cross to explain there is a discrepancy. And he did it nicely, too, because she's an extremely sympathetic witness. Yeah. He He didn't beat her up. He just said, but you didn't say this before. He said it in a kind, soft, lovable voice, but he still said, that was an inconsistent statement, sis. You didn't say that before. And the jurors heard that. Let the jurors figure it out.
Yeah, I agree. You know, at the end of the day, you know, it's something that they have to be very careful of when they cross-examine these witnesses. Jamie, I got about 30 seconds left. How bad is this for the prosecution or state in terms of excluding this testimony?
Well, I think the exclusion of the testimony is certainly going to hurt the defense for the reasons I've already stated. Now, Marie's correct. You know, to what extent, I guess, would be my question, is the court going to allow the defense to make these credibility arguments against Ms. Hale if her testimony doesn't exist technically?
Yeah, fair enough.
True.
All right. Thanks to Marie Pereira and Jamie White. Thank you both for being with me. We'll see you again, Marie. All right. Folks, stick around. We're going to have much more of today's hearing for Adrian Gonzales. So keep it here on Court TV, your front row seat to justice. Welcome back to Court TV Live. I'm Michael Ayala, and we are tracking several cases here today at Court TV. In Utah, an evidentiary hearing is underway for Corey Richens. She's the children's book author accused of poisoning her husband with fentanyl. And in California, defense attorney Alan Jackson is withdrawing from the case against Nick Reiner, causing a third delay in his arraignment for the murder of his two parents. We're working on getting you inside the courtroom there. And also in Texas, the judge has denied the defense's motion for a mistrial in the Uvalde school massacre trial against Adrian Gonzales. Right now, I want to take you back inside that courtroom for more of the state's response to that judge's decision.
Before you do that, really, I just want to know we have a response, if you would consider that. So.
We would also have a response to that, and just so we can explain to the court that our primary concern with an exclusion is that basically what's happened, and I understand the jury, and you'll instruct the jury to disregard. I think a lot of that testimony, though, is going to be difficult for them to disregard. A lot of it is emotional testimony. One of the things that we were thinking about as a remedy would be to allow us to play her statement to the Rangers in its entirety to the jury so that they can hear what she said in the first 4 days.
Well, I was going to give the option of, even if I exclude her testimony, you still, if you wish, could cross-examine her and do that.
Okay.
And then at the conclusion of that, my thought could be to exclude it at that time.
Yes, Your Honor. Because I guess my concern would be if we excluded it now and they haven't had an opportunity for it.
I was going to give you that choice, but you jumped ahead of me.
Sorry, Judge. I'm sorry. I got a little afraid. I'm sorry.
All right. Ms. Mitchell, what do you have?
Your Honor, we just have a state's response to the defendant's motion to exclude the testimony of witnesses as aged in anticipation of their motion. So I just want to file that with the court for the court's consideration. If you could file stamp this copy too.
Okay, well,
and that's my copy.
Good.
The first copy is for the judge. I'm sorry.
Okay, thank you.
I just want to file stamp copy.
Okay, so again, this is kind of a sua sponte remedy that I've devised. It's not really their motion. Did you file a written? Did you file something?
No.
Okay.
This is just anticipation of an oral motion to exclude, Your Honor.
Okay.
I don't know, Your Honor, can we confer as to possible remedies? And see if we can come up with a solution. Would the court be open to that?
I mean, if y'all agree on a remedy, I'm happy to entertain that, but I want the record to reflect that pursuant to Heath, I do have, discretion to craft a remedy any way I see fit. But what I've already done, for the record, is we have given a continuance to the defense until tomorrow, and we're having a hearing outside the presence of the jury to entertain potential remedies. and make findings of fact if necessary, but for the record, there was a motion for mistrial, and on that motion for mistrial, I'm going to find it's denied because I think the remedies available are sufficient to protect the due process rights of the defendant. And if y'all want to agree on a remedy, I'm happy to entertain that, but I have one in mind, and I'm going to give the defense some leeway on how they want to proceed with the witness in front of the jury in the event she's recalled after we talk. So take 15 minutes, y'all talk, and we'll come back into court, and I'll review the state's response to the oral motion and finish the other in-camera matters that were submitted to me. But is there a place, well, if you want to just go back to my office, I'll stay here, and you can go back to the office that they've provided me.
We have a room actually that they've given us over here that's...
Or you can go, actually you can go to the jury room if you want to, because nobody's there. But I'm assuming that contemplates conferring that everybody goes. The state joins you. Okay. That's fine. All right. Well, y'all let me know. We'll be in recess till you come back.
All right, so it sounds right now like the actual remedy is still up for some discussion. The state asking if they can perhaps get together and craft something that works for both parties. Sounds like they weren't too happy with the leeway that the judge seemed to want to give the defense in terms of how they dealt with that witness, if in fact she is called back to the stand. Let's bring on our guest for this hour. Joining us is former Los Angeles County Public Defender Philip Dubé. Philip, great to see you as always. Thank you so much for joining me today on the program. First of all, I want to get your response to what we saw today. The defense asking for a mistrial based on some information that came out that they did not have access to. We heard it from Stephanie Hale, a teacher at the school, talking about the location of the shooter in this case, as well as a more detailed description of that shooter. The judge deciding that a mistrial was a little bit too far and saying he had the discretion to decide some of the remedy. That remedy, at least as of right now, according to the judge, is to exclude her testimony, give the defense some leeway in how they deal with that testimony. Love to get your thoughts.
There is no way to predict every single fact that's going to unfold and be presented at a jury trial. There's just no way to know. And in fairness to prosecutors, they don't even always know. Sometimes witnesses come up with things that were never even told to the cops, never told to prosecutors, and much of it hinges on how the questions are propounded of the witnesses. So if we're honest, it's probably a surprise to both sides. But in terms of a Brady violation, to be fair to the prosecution, typically it's based on an intentional withholding of exculpatory evidence, meaning evidence that tends to exonerate a defendant. And I think that whatever was not disclosed to the defense, or either through inadvertence or, I don't know, accident, however you want to characterize it, really would not have exonerated the defendant or change the outcome in any way. It's just one of those facts that has to be developed through the art of cross-examination. But I do not believe that they were deprived of their ability to bring in an expert or a witness to counter what it is that civilian witness had to say.
Yeah, Philip, I agree with you 100%. As I was looking, I went back to the statute to sort of figure out what Brady involved in this particular state, if it was different, because I didn't find that information to be particularly exculpatory. And at the end of the day, I thought even helpful to the defense, because there's a number of different descriptions as to where the defendant was and where the shooter was, which I think goes to the crux of the prosecution's case.
Exactly, and that's very common. If in this situation, the evidence that came out through that teacher didn't have any tendency to exonerate officer or former officer Gonzales, then we really don't have a Brady violation. Really what you have is some fact in evidence that the defense didn't know about. And whether or not that fact could actually turn the verdict, that remains to be seen. But to fault the prosecution or even fault the defense for that non-disclosure, I think is I think it's gone too far, frankly, to say not the defense gets a new trial. So instead, what you do is you kind of put the trial in a brief intermission to allow both sides to get their gears going and figure out how they're going to go forward. But I don't think the remedy is quashing that entire jury panel and starting anew.
All right, so now they've gone back and they're going to try to fashion some sort of a conclusion to this situation. It sounded like the state wasn't too happy that the judge is going to allow them to sort of do what they want almost with the testimony of Stephanie Hale, going to allow them to use it perhaps later on to contradict other testimony or in various ways, basically not, there was no outcome that was sure. So it sounded like they wanted a little bit more surety in this whole thing. What do you think might happen in this discussion as to what this ultimate conclusion might be?
Well, the brief continuance is one surefire way to remedy it. If the defense feels that they were hampered by this sort of late disclosure of evidence mid-trial, then what you do is you give the defense a little time to work on it, develop it, figure out how they want to cross-examine the witness. Or certainly there are probably facts that were adduced through the witness that they could use to their benefit. And sometimes when you're not alerted to whatever facts the witness sort of laid on everybody last minute, you need a little time to get your thoughts together. So you put it over a night. And if we're honest, Michael, it's really not that big of a deal. I mean, they're carrying on as if this particular fact would have set Officer Gonzales free. It's just some fact that they were not privy to that I don't believe would turn the case for or against the defense.
Yeah, and I think that's kind of the what the judge was sort of alluding to as he was saying, look, I'm not going to go that far under these circumstances. All right. Stand by, Philip. My understanding is that folks have returned from that little discussion they were having. They're in the courtroom. What we'll do now is we'll take a break. When we come back, we'll take you back to that courtroom to see what kind of conclusion or solution they came up with for this problem. Keep it here on Court TV. The front row seat to justice.
I'm going to ask you a lot of intensely personal questions.
From the crime scene to the courtroom, this is Victim to Verdict.
Everyone has this heightened sense of anticipation.
What a day here at Court TV.
Fireworks both inside and outside the courthouse.
Let the cameras roll.
Welcome back to Court TV Live. I'm Michael Ayala, and we are in Texas bringing you the Uvalde school massacre trial against Adrian Gonzales. Now, he's the first person to stand trial in connection to the 2022 deadly shooting at Robb Elementary School. 19 students and 2 teachers were killed that day. Well, now Gonzales faces 29 counts of child endangerment and abandonment. Again, he was a police officer on duty that day, one of the first ones at the scene. Now, moments ago, the judge denied a defense motion for a mistrial over what they called new information in a teacher's testimony that happened yesterday. But the judge said that he would exclude that testimony, and, well, at the end of the day, that's not sitting well with either the defense or the prosecution. So now both sides, they're trying to come up with a solution. Let's go back inside. We're still outside the presence of the jury.
So once again, we're outside the presence of the jury, and I'm giving counsel an opportunity to confer on potential remedies in regard to the witness. So what do y'all have to report?
Judge, we've had pretty productive talks, and I believe, and correct me if I'm wrong on any of this, that the proposition at this point, with them still reserving the right to think of it overnight and start in the morning, is that they continue their cross-examination. They get to also play the entire statement that she made. We would then get to redirect, and then they still reserve the right to ask you to exclude all the testimony. And
yeah,
that part we feel comfortable.
Yes, Judge, and under the idea that we want to unring the bell first before there's an instruction to exclude it, because and have them exclude it all in its entirety, which is fine. But we would like to be able to unring that bell and then make that decision. Depending on how that cross-examination goes, we might not ask to exclude her, because there are some things that she says that we're just trying to evaluate her testimony after it is to see, on balance, is it more beneficial to our case, or is it not? Like, you know, after we've unrang the bell. But if we determine on balance that it's less beneficial, we would still like to have the Heath remedy for the late disclosure.
Well, for the record, I'm offering it right now. I'm offering the Heath remedy to exclude her testimony immediately. But if y'all want an opportunity to try this, if both sides agree, I'm happy to implement that agreement.
Yes, Your Honor. What we believe is ultimately we believe we're asking the court to exclude. The only issue is that we just want to be able to unring the bell first.
All right.
Is the idea.
And I know I told her, but she knows she's supposed to be here at 9 o'clock tomorrow. Okay.
Yes, Your Honor. Additionally, I will say that that in light of it, whatever harm that the court has determined in the defense case strategy, or in emotional impact, we would add that, and we do believe that under our 403 motion and motion in limine under the autopsy photos and the like, that it would start to, that the court should add that in the 403 balance, because part of what was not disclosed is something that is, I guess, on an emotional level, especially in what this witness testified to has a tendency to prejudice the defendant. She was taking shots. She was actually personally traumatized by these things that we are going to show that she has never said before. But the jury, having heard that, we believe that it should be a part of the 403 balance when the court eventually, I know you haven't made your final decision about what it is, but I would just, for the record, I would say that it can compound the harm if there's a disclosure, and then the probative value, whatever that is, of them trying to get into these photos of these children, are the prejudicial danger is compounded by something like this occurring in the trial, as to how it can affect the jury. And so I just wanted to put on the record now, I know the court hadn't made the decision, but just to put that in the court's mind that we are also going to be arguing that at a later date.
All right.
And Judge, I just wanted to be clear, because I originally heard the court say, I wanted to strike all the testimony now, but I'm also willing to entertain the defense's claim.
I want it on the record, because I've denied the mistrial, that in lieu of the mistrial, I'm ready to exclude the testimony now. But if you all want to agree on this, then I will implement your agreement.
Could you give me 1 minute then? I'll be through.
Yeah, and I guess yes. I think just the court understanding, willing to strike now would the only reason we're not accepting that. What I don't want to do is be in a situation where I'm on the record saying that I don't want that court's remedy, because then the courts later will say, well, then if you didn't want the court's remedy, then how can you claim that the mistrial was wrongfully denied, right? So what I want to do is just say that the reason we don't believe that striking it now, and like she just goes away, is that we'll never have an opportunity to unring the bell.
And we think that the court's remedy of striking it all now is sufficient.
Right. You see what I mean? And so what it does is it puts us in a situation where that remedy could actually harm our client worse by.
Well, all right. Well, we'll let the defense proceed as we just discussed, and she needs to be here at 9 o'clock in the morning, and then I'll make a decision on exclusion with everybody's participation after we rest and or actually she's finished with redirect and recross, whatever the case may be.
Yes, sir.
But my recollection is she's on cross now.
She is.
Okay.
We left off where I was refreshing her with her statement, and then that's when this issue came up, and so I would just continue with the cross-examination.
They've passed her and she's on cross.
Yes, Your Honor.
Okay. All right. Very good. All right. So 9 o'clock tomorrow with the witness, and we will proceed at that time. Thank you very much. We'll be in recess.
All right, so I just want to remind folks that yesterday after this happened, the judge did grant a continuance to the defense and in effect the state. For today, they would only have this argument. They were set to begin tomorrow. Sounds like they will. And this witness will continue her cross-examination. There'll be an opportunity for them to redirect the state to redirect. They're also going to play her statement in full that she gave to police as well to show some of the inconsistencies. But let's bring in our guest with us, former Los Angeles County Deputy Public Defender Philip Dubé. Philip, I got to say, it sounds like the defense wants their cake and they want to eat it too under these circumstances. They want to say, look, you want to exclude it now, Judge. We don't want that. We want to unring the bell. But if, in fact, we want to hold on to the opportunity to argue later on that if by going through all that, we continue to prejudice our defendant based on her testimony, we want to be able to argue that there is 403 violations, that it was more prejudicial than probative. The judge seems skeptical, but it sounds like he's going to let them go on.
Yeah, I think both sides dropped the ball, Michael. Here's what should have happened. It sounds like the defense and the prosecution didn't properly interview this witness before the trial and really home in on all the very specific, particular details that they wanted to introduce either on direct or on cross. So what the court should do, and I've seen it done, and frankly, I've been guilty of it myself, where things come up mid-trial, you didn't know that a witness was going to say on direct or cross. So what you do is outside the presence of the jury, you take the witness on voir dire, almost like an expert. So you get like a mini dry run with the witness and develop everything you want to know and need to know for the trial. And based on that, you can make a decision as to whether or not this witness's testimony should be stricken. Now, if I were the judge, I would allow the voir dire, but ultimately, in the end, what I would do is not exclude the testimony. Instead, I would bar any further mention of the testimony, and I would bar counsel from mentioning any bit of her testimony in their closing arguments. That way you minimize the harm and you cannot argue foul on appeal.
But the problem with that, and the defense brought this up, Philip, is they want to be able to use some of that testimony to impeach some other witnesses who say that he was in different places at that time. They want to point out to this jury, well, we have this witness saying he was here. This one says he was there. This one says he was over there. And the opportunity to do that, I think the defense rightly argued, is still very important to their case. So they feel like they need it. And you even heard him say, Philip, I can't decide just how helpful or hurtful it is to our case.
No, that's where I actually kind of disagree, Michael, and I'll tell you why. If the defense really wants to score points with this witness, they don't have to do any further cross. You know what they can do? They can call her as their own witness in the defense case in chief. And through their direct, they can bring out whatever exculpatory or exonerating or otherwise helpful testimony they need to defend former Officer Gonzales. But I think going into a further cross on this only highlights the flaw or the error in that non-disclosure. So I would walk away from it. I would recall her during direct and try to score whatever points you want through your own direct examination.
You know, Philip, why this testimony is so important really sort of centers in on sort of what's at the heart of this case, and that's time, right? We know that 77 minutes are being claimed by the prosecution, and again, it's important because it shocks the conscience, it adds to the emotion of the case. But what's really important, at least what I took away from not only the issue with this testimony, but opening statements by the state, is those first few minutes. Where was he? Where was the defendant? What could he see? What could he not see? And that's really what's sort of focused in by this defendant. I want to play some video of body cam during this incident just to get a sense of how chaotic it was and how difficult it really can be to narrow down where people are and what's actually happening. Let's take a listen.
Shots fired in the building. I heard somebody say somebody was shot in the head. Which building? I don't know. They haven't said anything. Hey, we going in or we staying here? What are we doing?
Let's set up perimeter, bro.
He's in the class. Dude, if I got shots fired, we're gonna be in the building, the west side. Dude, we gotta get in there. We gotta get in there. He's shooting.
Look, what jumps out at me, Philip, is you can hear this guy, he's hyperventilating. I mean, the whole situation, chaotic. It's understandable people might get facts wrong, but they're focused in, the state is, on those first few minutes, but then you got the 77 minutes where over 400, or at least up to 400 folks show up, police officers, law enforcement personnel. No one goes in for 77 minutes. Is that particular fact helpful to the defense, that not only did this guy not go in, but 400 others didn't go in?
Of course. I mean, you have such a frenetic, chaotic situation. They didn't know what they were up against. And you got to understand, Michael, this was a pretty narrow, sort of tight, closed-in hallway where to get in there and breach that threshold, you put your own life in danger. They call it the fatal funnel. And cops get, frankly, limited training, especially at the school resource officer level, on how to avoid fatal shots during these types of school shootings. So what do you end up with? Well, really what you end up with is not enough police presence on campus. I mean, look at the ratio of teachers to students. In a classroom alone, you have 25 students for one teacher. I don't know how many school classrooms are on campus at Robb Elementary School, but you would think that they would have a much denser, higher ratio of cops to students. And to say that, you know, this one school officer can thwart the overthrow of government, for lack of a better expression, by dealing with all that AK-style rifle firepower, I don't think is realistic. Not to mention, I don't care what battle you're in, they always say that many a frightened soldier desert while under fire. And I think that is in part what happened here. Now, whether or not that makes him legally derelict, that's for the jury to decide. But frankly, I think that what he did is really excusable under the circumstances criminally, maybe not civilly, but criminally.
All right, we'll have to see what the community thinks in the form of that jury. All right, stand by, Philip. We're going to take a break. I want to remind folks, court there it will resume tomorrow, and that's at 10 a.m. Eastern, with that teacher taking the stand again, continuing her cross-examination by the defense.